Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case.
The judge has declared a mistrial in the case of Karen Reed, who's accused of fatally striking her Boston police officer boyfriend with her SUV. Reed was charged with second-degree murder and several other charges for striking police officer John O'Keefe and then leaving the scene and returning several hours later. He was found in the snow and later declared dead at a hospital.
At the same time, those jurors who would find the defendant guilty ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury.
The juries twice came back to the judge saying they couldn't reach a verdict. The prosecution on Monday implored the judge to keep them going, saying that this case involving more than 600 pieces of evidence, 74 witnesses, over 29 days of testimony, required them to take more time. The defense, since the first time the juries came back and said they were deadlocked, said it's time to end this case.
That is no mistake.
This will be a win for the defense, who had basically argued she was framed. They argued it wasn't Karen Reed, but several other possible people who were responsible for O'Keefe's death. They say that Reed dropped O'Keefe off at a house party. He got into a fight inside the house and was left outside.
Before Trooper Proctor had access to the SUV, and you have an independent police officer telling you so.
12:37 is when the defendant leaves this voicemail.